Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony. Court will accept into evidence states exhibits 1 and attachments and review the same.
He was facing years in prison, but the judge gave him a choice that could change everything. Now, his future depends on one decision.
Hello, why were you late for court?
I'm sorry, ma'am. I have a prosthetic and I was parking. I
Okay,
apologize.
all right. Just make sure you're on time, you understand?
Yes, ma'am.
All right, thank you. All right, the court is calling 2025 CR 010538 State versus Gary Hernandez. Could I have parties announced?
Florence knows for the seat.
Tony Jimenez from Mr. Hernandez.
And are you Mr. Hernandez?
Yes, I am.
Counsel, have you received all discovery? Did you review it with your client?
Yeah,
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the application for probation with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, yeah.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive count 1 and proceed on count 2.
Any objection?
None.
Mr. Hernandez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did, Your Honor.
And count 1, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was wrong.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 6 years in the prison. There's no application for deferred adjudication. The state is silent on your application for community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, no.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Yes, Judge. Plead offer states exhibit 1 and all attachments.
No objection.
All right, did you review the waiver and, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial?
Yes.
A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony. Court will accept into evidence states exhibits 1 and attachments and review the same. Court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Not at this time, Judge. Change my mind. I'll go forward, Judge.
Right. Anything you wish to say on behalf of your client?
Judge, there's a number of things. My client is an amputee. He's on Social Security benefits right now. CPS was involved in his case. He's at the process whether is it going to be a reunification sometime in January or February of next year. He's consistently visited his child who's in Travis County right now, Austin, Texas, with his wife. He's completed various classes in order to have reunification recommendation by CPS. Those classes have been provided to the state's attorney. He's completed additional classes with respect to his drug use. He was at the time addicted to methamphetamine. He was making contact online, hoping to sell or feed his dependency on methamphetamine. He's overcome that. He's been clean ever since, not only because of supervision by CPS, but also supervision by the pretrial service officers. He's respectfully asking the court for its consideration and granting him probation in this case.
All right. I'm going to give you a choice. I read the stipulations. Here are your choices. One, I can grant your application, or I'll sentence you to 2 years in the prison. Which do you prefer?
I would prefer application probation.
All right. So what are the conditions CPS have with regards to your children?
Right now, we have classes for BIP
Mhm.
over in January 5th. Once that's completed, I've already completed parenting, outpatient. BIP is the last thing we have to do. I'm in therapy, family therapy, individual therapy. And I just got a doctor referral for a psychiatrist as well, which they recommended. We should be done with everything by January 5th, by January 5th. And February is when we get our daughter back.
Okay. So what is your visitation schedule?
Right now, it's every week for 2 hours, but starting next week, it starts every 2 weeks for 4 hours.
And is that supervised?
It's supervised right now, yes.
Okay.
And then we do 1 week family therapy sessions by Zoom.
Okay. All right. This is what the court is going to do. As previously stated, the court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no unsupervised contact with minors. Once your visitation changes with CPS, let me know. What I can tell you, in order for me to change the no unsupervised contact with minors, your caseworker will need to Zoom in so that I can speak with them. There's going to be field visits 1 time per month until further notice. And are you staying in Bexar County or Travis?
No, we live in Bexar County.
Okay. There's to be compliance with CPS, a TAP evaluation and MIC evaluation out of custody, and probation. If you could confer with the CPS service plan to make sure that nothing's overlapping. So if there's mental health that's needed, if they're doing it on the CPS side, you can just allow the CPS side to do that. There's going to be 100 hours of community service restitution. If he's completed the parenting classes on CPS, that'll go towards the community service hours. You're welcome. There's going to be proof of employment or SSI within 45 days. There's to be no employment as a home health care provider or with minors. And are you currently doing any type of sober support meetings?
Yes. So I'm still doing 2 classes every week.
Mhm.
And then I'm sorry, it's 3 classes, 2 by Zoom and 1 in person every week with lifetime recovery.
Okay, and he's to continue sober support meetings with lifetime recovery. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, Your Honor. Thank you so much for the chance.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and
Yes.
sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney.
I understand.
Okay. All right, we can go off the record. Here's the thing. I used to do a lot of CPS cases in the past. Make sure that you stay on track. Do not have step on anything, because once you have slip ups like, oh, well, I missed my meeting today, I'll just double up on it. You will look up and find that you've gone completely off track. All
Oh, I
right.
know. We worked very hard and we have 2 more months. We should be back with our daughter. So
Okay. So here, and I'm telling you, if you're not going to stay clean and sober for yourself, you really should do it for yourself. But if not, do it for your child.
and that's it
Because
for me.
your child is not even in Bear County, right? They spread children when they are in CPS care. They spread them throughout the state, and that's because they don't have placements for them.
She went
in
to
different places.
for Austin. So I know it's hard.
Yeah, it
I know
is.
I know she's feeling it too.
And sometimes they take them out of state. Okay? All right. In this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know about it. If you feel they're not addressing it, you can always come back to court.
Thank you, George.
All right, good luck to you, okay?
Appreciate it so
Thank
much.
you, Judge.
You're welcome.
Please.
Yes, you're welcome. Court is calling 2025 CR 008924 State versus Alexis Hernandez. Can I have parties announce?
Will Brooks, appearing for Luis Martinez, behalf of the defendant. Judge.
All right, any objection to this attorney standing in for Mr. Martinez?
No, ma'am.
Counsel, have you received all discovery?
I believe Mr. Martinez acknowledged that he had, Judge.
All right, and did your attorney review the discovery with you?
Yes, ma'am, correct.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am, correct.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with stalking. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to proceed with trial. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
But can you repeat that one more time?
All right. You understand you have a right to jury trial,
Oh, yes, ma'am, correct.
right to remain silent,
Yes, ma'am, correct. Sorry about.
right for your attorney to cross-examine any witnesses?
Yes, ma'am.
Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into this plea bargain agreement?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,500 fine. State is recommending deferred adjudication. Protective order. Did you understand that to be the plea?
Yes, ma'am, correct.
Defense,
Yes, Judge.
state,
Yes, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, correct.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, it's my understanding there have been no such motions.
That's my understanding. Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years, 200 hours community service restitution, anger management, TAP evaluation, and follow all recommendations in MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am, correct.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State would offer State's Exhibit 1 and all attachments.
No objections to state one or attachments, Judge.
And state, have you spoken with the complainant?
We have, Your Honor.
All right, state, you may be excused.
Thank you, Judge.
Sir, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am, correct.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am, correct.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the scene. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We'll waive a PSI and proceed with sentencing today.
All right, how old are you?
I'm 21.
All right, you all, according to this, have only been dating for 2 months. So do you live with your parents?
No, I don't.
You live by yourself?
I live with my girlfriend right now at the moment.
So you now have another girlfriend.
Yes.
All right, so this is what I understand. When somebody says they don't want you anymore, you have to accept that. I don't even know how you would find time to text hundreds of times. That's a lot of texting,
People's fingers are so fast these
Yeah.
days, Judge.
especially when you're my age and you have to do complete sentences with the right caps. Yeah.
To hold the phone up in there.
And then driving by somebody's home.
Judge,
And
it
yes,
is my understanding that since this incident, there's been no contact. He's been subject to a protective order aside from the lifetime. And there's been no issues with violating that protective order. Judge, I didn't mean to interrupt you.
no problem. So do you understand when somebody doesn't want you any longer, it's over?
Yes, ma'am. Correct.
And this person that you're in with a relationship now, are they aware of this?
Yes, correct.
All right. So if this person you're in a relationship with now tells you they don't want you anymore, you call it a day. You know. What's the Bonnie Raitt song? I can't make you love me if you won't.
We should all adhere to that.
Yeah, you got to move on. All right, the court will sentence you to 6 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs. Proof of employment. Are you currently employed?
Yes, ma'am.
What do you do?
Construction.
All right, proof of employment in 45 days, no employment as a home health care provider or with minors. There's to be no contact with.
In State of Texas v. Gary Hernandez, the court handled a felony plea and sentencing proceeding in which the state waived count 1 of the indictment and proceeded on count 2, while the defendant sought community supervision instead of prison. At the outset, the court confirmed that discovery had been provided and reviewed, that Mr. Hernandez had gone over the application for probation, the indictment, and the court's admonishments with counsel, and that he understood the nature of the proceedings. The judge advised him of the punishment range associated with the original charge described in the admonishments, explained that the court was not bound by any plea recommendation, and confirmed that by pleading guilty, he was waiving fundamental constitutional rights, including the right to a jury trial, to confront witnesses, and to remain silent. Mr. Hernandez stated that he understood those rights, had not been threatened or promised anything beyond the plea agreement, was satisfied with counsel, and understood the immigration consequences if he was not a U.S. citizen. The plea bargain called for the state to proceed on count 2, with punishment capped at 6 years in prison, no application for deferred adjudication, and the state remaining silent on his application for community supervision. He waived appeal, pleaded guilty, and agreed to allow the state to prove the case through documentary evidence rather than live testimony. After reviewing the stipulations, police reports, and related exhibits, the court found sufficient evidence and formally found him guilty. then moved immediately to sentencing. Defense counsel urged the court to grant probation, emphasizing that Mr. Hernandez was an amputee receiving Social Security benefits, that CPS had become involved in his family situation, and that he and his wife were actively working toward reunification with their child, who had been placed in Travis County. Counsel explained that Mr. Hernandez had consistently attended visits with his child, completed multiple CPS-required classes, participated in drug-related treatment, and had been clean from methamphetamine since the offense, with both CPS and pretrial supervision monitoring his compliance. Counsel argued that the offense had been tied to his former addiction, including conduct committed while trying to support that dependency, but that he had since made meaningful progress and deserved an opportunity to continue rehabilitation in the community. The court responded by presenting the defendant with a clear choice, either probation or a 2-year prison sentence. Mr. Hernandez chose probation and then described in detail the remaining CPS requirements, including BIP classes, therapy, outpatient treatment, and a psychiatric referral, stating that he expected to complete everything by early January and hoped to regain custody of his daughter by February. He also explained that visitation was currently supervised every week for 2 hours and was about to increase to every 2 weeks for 4 hours, along with weekly family therapy by Zoom. Taking those circumstances into account, the court sentenced him to 6 years in prison, suspended and probated for 4 years, rather than sending him to prison immediately. The conditions of supervision were extensive and tailored to both rehabilitation and the CPS case. Regular reporting by Zoom or in person, random urinalysis testing, no unsupervised contact with minors unless CPS circumstances changed and the caseworker appeared before the court, monthly field visits, full compliance with CPS, task evaluation and an MHC evaluation out of custody, coordination between probation and CPS to avoid duplicate services, 100 hours of community service with CPS parenting classes credited toward that requirement. Proof of employment or SSI within 45 days, no employment as a home health care provider or with minors, and continued sober support meetings through lifetime recovery. The court also advised him that because this was a felony conviction, he could not possess firearms or ammunition, and that his plea bargain eliminated any right to appeal. The hearing concluded with a firm but supportive warning from the judge that success on probation would depend on absolute consistency, sobriety, and communication, especially given how close he was to reunification with his child, making clear that any lapse could undo the progress he had worked to achieve.